Okay, thank you everyone for joining us today for our 18th virtual seminar. Today's topic is Point-Counterpoint, the Constitutionality of 18 U.S.C. 922 G1. This webinar, like many of our others, is eligible for CLE credit. If you're from Wyoming, you can just put it in. It's registered with the Wyoming State Bar. If you're if you're admitted somewhere outside of Wyoming, we can send you a certificate and whatever other information you need. Um, as many of you know, here at the Firearms Research Center, our goal is to enhance and elevate the public conversation on all things firearms, and that includes law, that includes history, that includes law enforcement, and any other area that's related to something firearms, something where someone's life or interests or work touches on firearms. And today, we're at the law and law enforcement intersection, I would say. And we're fortunate to have with us today two excellent speakers who'll be doing our point counterpoint. Uh, we've got Margaret Groban. She'll actually be speaking second today. She's a retired federal prosecutor and former National Domestic Violence Coordinator for the Department of Justice. She worked to uphold the federal domestic violence laws and to implement the laws with particular emphasis on domestic violence firearm statutes. Margaret is currently on the adjunct faculty at the University of Maine School of Law, where she teaches a course on the Second Amendment and firearms regulation. And then we've got Lahny Silva. She's a professor and a scholar and educator at the Indiana University Robert H. McKinney School of Law. Her work focuses on the collateral consequences of criminal convictions, particularly in housing and with firearms. She's been widely cited by courts and legal scholars, and she's the director of the law school's reentry clinic, where she mentors students and helps individuals overcome legal barriers to successful reentry into society. Our format today, as we mentioned, will be a point counterpoint. So Lahny will be speaking first. She'll go for about 20 minutes or so, and she'll have a PowerPoint presentation. Then Margaret will speak for 20 minutes or so. Then we'll do a little bit of a back and forth. And then if we have a few minutes left over, we can do some Q&A. And we can go over a couple of minutes if we need to, so don't worry about that. We're in the Zoom's webinar format, so for the Q&A, we'll be using Zoom's Q&A feature. So there should be a little button somewhere in your Zoom interface that says Q&A with a little question mark and the little cartoon bubble. Just put your questions in there, and then we'll collect them up and then get to as many of those as we can at the end. So with that, once again, thank you for joining us, and I will turn it over to Lahny.
Thank you so much, George. I'm just going to go ahead and pull up my PowerPoint presentation. Sometimes this is a little wonky for me. Okay, as you can see, I love Tupac. Okay. So thank you again, George, and awesome Firearms Research Center. I am so pleased to be presenting today. I'm also excited to present with Margaret. We had some great conversations at this conference we went to, so I'm so happy to be presenting with her. So today I'm going to talk about 922 G1 and challenges to it. I wrote an article about it. It's entitled Notes on the Second Amendment's Dangerous Dilemma, the Other Dangerous People. And so for today's talk, I'm going to talk a little bit about my thesis. I'm going to discuss why I think 922 G1 fails under Bruen. I'm going to talk about the dangerousness principle, specifically categorical dangerousness, and how the circuit courts are using dangerousness to uphold the statute. And if time permits, I will then talk about some of the remedies that I propose to hopefully provide some clarity on the rule. Before I get into the nuts and bolts, I just want to talk about the scope because the scope of my comments is kind of limited. So I'm only going to be focusing on federal law, so I won't talk about any state statutes. My analysis is limited to the colonial and founding eras, most notably because that's where Rahimi's analysis stopped. And I'm not going to be delving too deep into loyalist or religious disarmament at the founding era, because many historians and certainly the courts that are addressing this issue have written volumes on these two types of categorical disarmament. So I'm really just trying to focus on those other groups that don't get as much attention. So my thesis is that 922G1 is unconstitutional. It's unconstitutional because it does not survive constitutional scrutiny under Bruen. There's a second reason as well, and that is that categorical dangerousness is constitutionally unsuitable, and it is because it's wrong as a matter of constitutional interpretation. So, as a good law professor would do, I'm going to provide you with the language of the statute. I wanted you to see it. I wanted you to feel it. If you notice, the word felon, felony is not in the statute, but it is implicitly. So, for those of us that practice criminal law, we know that generally anything over a year and a day for imprisonment is typically a felony. There are exceptions, but that's beyond the scope of the talk today. You'll also notice that I pinned 925C, which is the federal felon restoration of rights statute that was defunded in 91, and then defunded again in 92, and has kind of been a dead letter for a while. And DOJ is doing some things, but I'll talk about those later. I think these two go hand in hand for purposes of our discussion today. So, why do we care about 922G1? Well, really for three reasons. One, the current disarmament trends. And what I mean by that is that disarmament, at least criminally, really has disproportionately fallen on Black people. So I wanted to read you some statistics so you would understand how much of that burden does fall on Black people. So for 922G1, which is our statute, 56.2% of federal convictions are of Black folks compared to 24.2% of white folks. 924C, which is the drug trafficking with a firearm statute, 58.9% fall on Black people versus 29.5%, which fall on white people. And then the Armed Career Criminal Act, which pretty much involves some kind of firearm conviction, either in the past or the present of the defendant, is disproportionately enhanced for Black folks. So 73.7% versus 15.7% of white folks. And so we see that there is definitely some asymmetry there. But also when you take into account gun-related deaths, and what group is dying most by guns, it's by suicide. And so you also see an asymmetry in that. So 58% of gun-related deaths are suicide, and suicides are often demographically within the purview of white males, and elderly white males disproportionately commit suicide. So again, the disarmament trends, in my view, are not really squaring with what's happening on the ground. The second point is we need a reliable rule here. And right now the circuits are split on 922G1. A fundamental precept of criminal law is that we have understandable rules that have been published to us so that we can conform our conduct. And when we don't have those reliable rules and it's a moving target, it calls into question the legitimacy of our system. And so we really need to kind of get this figured out. And then the third point, which may be perhaps the most important point for many of you, is freedom, fidelity to freedom. And so, for better or for worse, guns have been intricately intertwined with our national pride and our idea of freedom. Independence was won with guns. And our American forefathers, both groups that eventually would become the Federalists and Anti-Federalists, believed in an armed citizenry that would ensure liberty, among other things such as survival at the colonial and founding eras. Guns were part of America, the creation of America and the founding of America. And so, and it's very much intertwined, as I said before, with freedom. So these 3 points are really why we should care, and they're important. So where does that leave us jurisprudentially? Well, we are in a very exciting time for the Second Amendment. We've had quite a bit of a revolution in this century. So starting with Heller, we now have a clear fundamental right to bear arms for the purpose of self-defense in the home. That was later expanded in McDonald to apply to the states. And it was geographically expanded in Bruen, now allowing for that right to bear arms for self-defense to, leave the home, the threshold of the home, and enter into the public arena. Bruen's important for another reason, which is that it reshaped the constitutional analysis for Second Amendment challenges. And then we have application cases that have come down. We had Rahimi in 2024, and most recently Hemani was released last week. And I'll talk a little bit more about those in a minute. But, has the Supreme Court said anything about 922 G1 and felon prohibitions? And the answer is yes in dicta. The Supreme Court, starting with Heller, stated that these prohibitions are presumptively constitutional. This line has been reiterated again in Rahimi, Hemani, and so, but yet not in Bruen, right? And of course in McDonald. So almost all of the Supreme Court cases have taken that line and have used it, and the circuit courts are following suit. But for me, that's really not enough. We have to apply Bruen. And so that's what I want to do with you today. I want to apply Bruen to 922 G1 and go over the test. And so for those of you that don't know, the Bruen test is a two-part test. Step one of the test requires that the plain text covers an individual's conduct. And if it does, then, the Constitution presumptively protects that conduct. So the courts have been trying to determine whether or not there is a textual mooring, and many have found that there is, because felons belong to the group enumerated as the people in the Second Amendment. So most of the circuits agree that there is a textual mooring at step one. Step two, however, is where I think the statute fails. And step two really requires that the government justify this regulation by demonstrating that it's consistent with America's history and tradition of firearms regulation. To show this, the government has to produce a historical analog that's relevantly similar. And it has to be relevantly similar in two ways. There has to be a comparable burden on the right to armed self-defense, and that there also has to be comparability in the justification for the regulation. So, with that piece, there is no support in the text of the Second Amendment for a felon exclusion or any reference to crimes, and there is no support during the history of the ratification. Yes, the circuit courts do note dissenting delegations, and there were 4 of them. However, the language of these dissenting delegations that were proposing to exclude people convicted of crimes from having a firearm, that language wasn't adopted. And that was noted by now Justice Barrett when she was a Seventh Circuit sitting judge in her dissent in Cantor versus Barr, which addressed 922 G1, and she would have struck it down as unconstitutional. So for me, jurisprudentially, 922 G1 fails. But there's another part of the story that hasn't been told, and that is about colonial criminals, right? So this to me is perhaps the most exciting part of the argument. I examined colonial criminals to kind of see what was going on with them, and I found 2 things. One, there were lots of them during the colonial and founding eras in America. So 25% of the American population were criminals at the time of the Revolution. And 2, though they weren't treated the best, they weren't disarmed, and certainly not so once they were freed from a term of indentured service. So what does that mean? How did they get here? What's going on? Well, what happened was England transported its convicted criminals over to America in lieu of killing them, right? So what do I mean by that? Well, the Crown would grant a conditional pardon to people convicted of felonies in lieu of them being executed for their crimes. And the idea was that it was to be a win-win situation. America was starving for labor, and white folks to be living and working in America. And on the other hand, England would be able to pull from, the English purview all of these criminals that were getting executed. It really impinged upon this idea and ideology of liberty and freedom in Mother England. And so instead of keeping them there, they were shipping them over to America. Okay, so that's kind of piece one. They were definitely part of our society. But piece two is, well, did they have guns? And the answer is yes. Colonial criminals had guns, especially when they were freed. So, how do you know this, Professor Silva? Well, I researched it. And most times you see colonial criminals, once they were released from this term of indentured service, right, as part of their term of imprisonment, if you will, they became hunters. And so to hunt, you need a gun. Moreover, into the middle of the 18th century, folks that were coming over as transported convicts, once they had finished their term of indentured service, they were entitled to freedom dues. And freedom dues included money, food, and a musket. So again, we have firearms. And perhaps less persuasively, but evidence nevertheless, there were two kind of conspiracies of convicted transports. And these two conspiracies were not met with any legislative reaction, unlike that of African slaves, that when there was a conspiracy that was uncovered, there was almost an immediate legislative reaction. So I concluded that there seemed to be an acceptance, or at a very minimum, a tolerance of convict armament during the colonial and founding eras. So not only does it fail Bruen, the historical social landscape was very much telling for me that colonial criminals were allowed to have guns. My second argument is about categorical dangerousness. So I wanted to pull this out immediately because I'm not sure if many of you have read Hemani, but I was very excited and read Hemani immediately. And I see some inconsistency between categorical dangerousness in dicta in Rahimi and Hemani. So, in Rahimi, categorical dangerousness was almost presented as a given by Chief Justice Roberts, right? And this is the line that we see. Okay. But in Hemani, Justice Gorsuch, writing the majority opinion, cited Justice Barrett's language in Cantor versus Barr, where she essentially says, hey, I'm a little uncomfortable with this categorical dangerousness because if Congress labels a group dangerous and then disqualifies this group from having a gun, it essentially makes our Second Amendment defunct. It swallows up the rule. And so we're already seeing inconsistencies in the United States Supreme Court jurisprudence on categorical dangerousness. But even furthermore, dangerousness as a principle has a lot of problems. It's very abstract. It's really too general of a principle. And you see the court struggling with the word violence, never mind dangerousness in other cases. And so, some heavyweight criminologists and sociologists come down very hard on dangerousness, such as Norval Morris and Michael Tonry, and they find that categorical application is a problem. It sweeps up too many people in the rule and essentially disarms people that would otherwise or weren't intended to be disarmed because they're nonviolent and hence they are not dangerous. There's also a circuit split. Right? So are we going to disarm nonviolent offenders because nonviolent offenders are not presenting that violent dangerousness piece? And the circuits are split on that too. We have the Third Circuit beginning with Range saying, hey, we're not going to disarm nonviolent offenders versus the Eighth Circuit in Jackson that's saying, hey, we are gonna disarm violent offenders because, at the founding, it didn't matter if you were dangerous or not. We did allow for categorical disarmament. I will note that Range has I think, three opinions, and Jackson has three opinions. So if you look up these cases, just please make sure you're looking at the 2024 iterations. Okay, so what are the issues really in the federal circuits? And I found two. One is, I'm going to give you a kind of a spectrum of disarmament during the colonial and founding eras. But one is the circuit courts are either neglecting racialized disarmament and not talking about it, or they're using it to uphold 922 G1. And that is, for me, really a problem that we're going to use an unconstitutional law to uphold the constitutionality of another. And the second issue is this idea of group disarmament, or should we be requiring individualized disarmament, right? Or at least individualized findings of dangerousness to disarm. Okay, so those questions still remain kind of unanswered, but I think that the court is we're gaining some traction in the court on point one, and we are, at least the justices seem to be recognizing an oral argument that there are some issues maybe with group disarmament in point two. But why is racial disarmament even important? Well, racial disarmament is important because, like 922 G1, it was a lifetime ban. Right? So here is the spectrum of disarmament during the colonial and founding eras. So the English tradition was to disarm, and I'll get into this in a second, dangerous and disaffected people. That was really a group or groups that were considered to be treasonous or potentially seditious. But once you swore allegiance to the crown, you were reinstated. You could have a gun again. The American tradition followed that dangerous and disaffected piece. So loyalists and Catholics that were thought to be potentially seditious were disarmed. But if they swore allegiance to the Republic, then they were reinstated. What about these kind of other groups? So some Native Americans that were disarmed were able to get their firearms later on. And what I mean by that is, as time went on, unlike just swearing an oath of allegiance, as time went on, these Native American disarmament statutes started to fall off the books, which is very different from what happened to Black people. So Black people hardly ever had any type of reinstatement, restoration, or even ability to possess firearms. And so these two groups, when there was a ban or a prohibition, were disarmed for life. And then what about convicts, everybody? Well, they were never disarmed, so restoration wasn't a problem. And so here is kind of our sliding scale spectrum of disarmament during the colonial and founding eras. But I did want to give you a little information on the English tradition because I think it's important. So the English tradition, like I just mentioned, was really focused on sedition. And so, this disarmament really started in the 7th century and gained tons of traction in the 16th, the 17th, and the 18th centuries. And it was categorical disarmament, very narrow definition, but again, you could be reinstated if you swore an oath of loyalty to the crown. Dangerous was the equivalent of treasonous. But this was not the case, however, for the other dangerous people in America. So for Native Americans and Blacks, and they were considered dangerous for different reasons. So Native Americans were considered dangerous because they were considered savages. And when they were disarmed, it was a lifetime ban. There were statutes disarming them, but they were only disarmed if they were enslaved. So that was a difference between, Native Americans and Blacks, which I have a slide about in a moment. The firearms trade was banned, so white colonists were prohibited from England, from the Privy Council, but also by the colonies themselves from engaging in the firearms trade. But guess what? White colonists still engaged in the firearms trade with Native Americans because it was too lucrative. The money was too good. And although the framers admired Native Americans and wanted there to be some, immersion with Native Americans in this new country, they still found them to be dangerous if armed. And so Native Americans were thought to be dangerous for a different reason than loyalists and Catholics that were thought to be seditious. Well, what about blacks? Well, blacks were thought to be dangerous because they wanted to be free. And educated blacks were thought to be actually the most dangerous. They were disarmed for a lifetime. It was a statutory disarmament. They were disarmed if they were enslaved or free in different colonies. And there, of course, were exceptions. Some colonies allowed free blacks to get a license, but many of those statutes ended up being repealed after the American Revolution. Blacks were also allowed to have guns in some instances if they had the permission and supervision of somebody white. And then blacks were allowed to have guns when there was a man shortage in the militia, when there were not enough bodies to actually fight. And you did see this during the American Revolution on both sides, and you also saw it during many of the wars. And so the definition and idea of dangerousness for these two groups would be unconstitutional today. Yet, the way 1920 G1 is operating, it's operating similarly to these types of statutes. Um, then remedies. Well, what are we doing here? Oh, sorry. 925C is actually been, at least DOJ is attempting to resurrect the statute, but they are perpetuating that dangerousness and categorical disarmament. So for me, that's not helpful. It doesn't really combat the problem. So while I don't like dangerousness, I think we can still make these kinds of determinations in a criminal prosecution. We already make individualized dangerousness determinations now. And so I think that it could be helpful to make these determinations for every criminal prosecution where the prosecutor would have to charge it in the indictment, and then a fact finder would have to make a decision. The other remedy I propose is let's stop making dangerous people to the extent that we can. So sure, some people may just be wired differently, but I tend to think that people growing up in circumstances where they are in a safe area, they are educated, and they have some real pro-social role models and institutions can make a difference. And the research bears that out. So community investment in community safety networks does reduce crime and violence in any given area. And so that's what I would propose as an alternative to this categorical disarmament in 922 G1. And that is all I have. I'm excited to hear Margaret's comments and to hear your questions.
Thanks so much, Lahny. I found that really interesting, just as I did. We met recently at the Duke Firearm Work in Progress Conference, and I was so thrilled to meet you and George and all the other faculty who I'm learning so much from, and to have a fulsome discussion about the future of all the federal firearm statutes. I do have an implicit bias, maybe not so implicit, having been a federal prosecutor for over 30 years and prosecuted firearms cases. And this is a really difficult time for federal prosecutors. Lahny and I agree, we need to figure this out for everybody. If you bring a federal firearms case right now, you have to both be a historian and a prosecutor. This is not really a tenable situation for anybody. So I think we do have a lot of common ground. We do diverge at some point, but our common ground is I think we both want to ensure the safety of our communities by preventing firearm possession by people who would endanger that safety. And to me, that primary role falls to the government to determine how we keep our communities safe. We also have common ground that the Second Amendment, like other constitutional rights, is not unlimited. That both Heller and Bruen and Rahimi and Hemani, all these cases say time and time again that the Second Amendment is not absolute and that there are limitations that can be imposed, and that the enactment of laws is the way to make sure that our communities are safe. So my thesis is that 922 G1 is constitutional and that the governments have roles in creating categories of persons who are not only considered dangerous. I agree with Lahny, that's a very amorphous, difficult term, but also people who have shown disrespect for legal norms, who have shown that they pose a special danger of misuse because they have failed to comply with our kind of social contract that you will not violate certain laws. So I find the argument very compelling on some level to have an individualized assessment, but I think this ignores both the historical tradition of category analysis and also ignores the important role from the founding that governments play in ensuring that the communities are safe. And that is a critical role to me that is like the 10,000-foot umbrella for all the considerations of these laws. And that is those legislators, federal and state elected legislators, rather than appointed judges, who should be determining whether or not the strategies that are being used combat violence while also respecting the Second Amendment rights of individuals. And I think there's some different worldview here. Some may think that an armed society is a peaceful society. Some may think that an armed society is a less peaceable society. So, but I hope that those worldviews wouldn't influence where we come out on the jurisprudence of all this. So I think my context on how we got to this, to me, is very important to start in some respects with 1968. Which was the passage of the Safe Streets Act, the Gun Control Act, and this was long after the Second Amendment was ratified in 1791. And at that time, Congress was addressing a widespread violence problem, widespread traffic in firearms across state lines, and was concerned about the ease with which any person can obtain firearms, including criminals, drug addicts, mental defectives, which is a term that we all wish would go away, and others whose possession of weapons is contrary to the public interest. And that was the impetus behind these laws as governments struggled with an epidemic of gun violence that was unknown during the colonial times. And even Bruen recognized, although we don't know what a nuanced analysis looks like if there is a crime that was unfamiliar at the founding, I think that we have to look at the prevalence of lawlessness and violent crime in the United States that led to the passage of 922 G1 and all the other crimes under 922. So by prohibiting firearms by convicted felons and others, Congress intended to place some burdens, but within the limits of the Second Amendment, that these were not crimes or prohibitions that would apply to law-abiding, responsible people. But there was there is now an exemption to 922 G1 for antitrust violations, unfair trade practices, or similar regulations that deal with business. So there was a recognition that the serious crime in 922 G1 was not universal. And the Supreme Court has recognized time and time again the purpose of the Gun Control Act, that it was broadly passed to keep firearms away from the persons that Congress deemed as either irresponsible, potentially irresponsible, or dangerous. So I think that the court has not limited it to dangerousness, and I understand Lahny's concern about dangerousness, but it also was the concern about the potential for misuse or irresponsibility. And that's a critical component of these firearm statutes. And Congress determined that the best way to deal with people who have been convicted of serious crimes and might be expected to misuse them was to create categorical, what do I want to say? Categories so that those people would not be allowed to have firearms. So that was the law there were earlier firearm prohibitions, but Basically, it was the Gun Control Act in 1968 that started the enforcement of federal firearms laws until 2008 when Heller was decided. And I think it's um, critical to note that Heller was a civil case because both Heller and Bruen were civil cases. And in Heller, it was a DC ban on all handguns. And the court, for the first time, said that there was an individual right to possess firearms as opposed to the right of the militia that had been the law in Miller, which was barely litigated. And so that at that time, though, federal firearm prosecutions were a staple of how the country was addressing crime and gun violence. So then Heller, for the first time, says there's an individual right. And this dramatic ruling, though, was narrowly tailored to the facts in Heller, although even if it's a civil case, that ruling would still be applicable in criminal cases. But it allowed for a two-step history and means and scrutiny process to develop. Heller didn't provide a test, which would have been pretty helpful for prosecutors going forward, but they didn't. And so the courts developed a test that applied from 2008 until Bruen was decided in 2022. And what was that test? What is the Second Amendment burden? Who does the Second Amendment apply to? And yes, some courts say it's all the people or those people who are part of the community. And others say if you are not law abiding, then you would not be considered part of the people. So courts came out differently on that one. But then what is the legitimate government interest that they have in imposing this burden, limited or not, on the Second Amendment? And from 2008 to 2022, there were over 1,500 cases decided, and all of them held the federal firearms laws to be constitutional. And these rulings were consistent. Even if the Second Amendment rights were impacted, if the court did not find that someone who's not law-abiding could be part of the people, they applied generally intermediate scrutiny, and there was a legitimate government interest that was documented by whatever evidence base there was for the initial prohibition under 922G, and recognized both a legitimate and necessary and critical role that government plays in providing for both community and individual safety. So that was the framework until 2024. And the important language, which Lahny has pointed out, and I don't know if the court appreciated that this sentence was going to be cited as often as it has on both sides. The court's opinion shall not be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons. And that it goes on to presumptively include both the mentally ill and sensitive places as well. So there the court is saying, on the one hand, we're creating an individual right, and on the other hand, don't worry, everyone. We're not really changing things here, and we're not touching the federal firearms laws. To me, that's how I read that statement. And that critical cast out language from Heller has kind of reinforced the constitutionality of firearm regulation. In fact, Justice Alito, who was a former U.S. attorney in New Jersey before he went on the bench, wrote in his dissent in a case, Rahimi versus the United States in 2019, and that was a case that imposed additional knowledge requirements on 922 prosecutions. And Alito was saying we shouldn't be doing that. We should not be limiting the impact of 922G. As he wrote, 922G is no minor provision. It probably does more to combat gun violence than any other federal law. So he was reinforcing, not unreasonably, the importance of 922G in the federal prosecutive format. And there's statistics to back that up. 88% of 922G prosecutions are of felons, are under the 922G1 category. It's the cornerstone of the federal background check system. Almost all of the background checks are based on felon, and it's around 13% of all federal cases. So it is no minor matter when those statutes are being are being either limited, expanded, or whatever. So post Heller, courts understood that there was an individual right, but that right was not without restriction, and that government had legitimate interest to restrict that possession as long as they could show a basis for that restriction. There was the consensus that, again, it was not unlimited and it does not provide a right to keep and carry any weapon whatsoever in any manner and for whatever purpose. So that's where we were. That was the landscape in 2022 when we get to Bruen, which again is a civil case. It was a civil case challenging New York's may issue permitting process. It was not a shall issue state. It was a may issue. The facts, which were pretty lean, and some of the dissent wanted to go back to New York to create a more fulsome set of facts, but it was a discretionary may issue process, and the court said that was not okay. And it was an opportunity for Justice Thomas to, I believe, express his extreme displeasure with what had happened post Heller, that all the cases were being upheld, that the Second Amendment right in his mind was still a second-class citizen, and that this was not consistent with what they thought would happen post Heller. So even though there was no split in the circuits and no federal statute had been held unconstitutional, the Supreme Court took the case and used this case to clarify, and I would say, in fact, drastically change the rule of Heller and say that that two-step process was wrong. All the lower courts for this 15 years or whatever had all gotten it wrong. And now that was one step too many. We only need a one-step process, although Bruen has evolved into its own two-step process, but different than what was in Heller. So instead, they replaced it with a test that takes us back either to 1791 or 1868 to search through history. And I would say this search is a thankless task, because I love all Lahny's research. I didn't know about colonists who were all coming over and they were criminals and they could have guns. But there's all this history on the other side as well. So there's history on both sides. Government lawyers like myself, we are not historians. So now we are, and I'm not surprised that some courts, instead of looking at assistant U.S. attorneys, are hiring independent experts to say, we can't muddle our way through all of this. What is the definitive history? And the truth is there is no black and white history. There's not, this is the set of facts that are true. These are the set of facts that are false. It's all one big kind of melting pot of different historical facts. And the court either puts weight on some. I know in Bruen, they didn't like the territories. They say those were outliers. They didn't like the number from certain states and they want more numbers. And all of it just leads to such vague option for prosecutors going forward to defend these statutes. So many questions remain. And since we all want to figure it out, Bruen was not helping in figuring it out. And Bruen, the concurrence, I don't know how Roberts and Kavanaugh didn't get this into the majority opinion, but there's the cast out language on federal prohibitions showing up again in the concurrence. Now, this was a civil case, but again, the applications were to criminal cases. So going forward, how has the Supreme Court looked at 922 G1 and particularly nonviolent felonies? They haven't accepted a case yet. They send things back. But let's look at Rahimi, because Rahimi is an important case in 2024. And I feel like it's a walk back from Bruen because it's a criminal case. And they are faced with a defendant who we all would agree was a menace both to his intimate partner and to society at large. So allowing that man to keep firearms was something that I believe on some level was intolerable to the court. So they're faced with 922 G8, which was enacted in 1994, not long-standing at all, but under the Violence Against Women Act, which added two new criminal provisions, one federal firearm prohibitions, one in 94 and one in 96, looking to address the dangerous combination of guns and domestic violence offenders, recognizing that in many states, like in Maine, where I live, domestic violence homicide is our predominant homicide. So how do we address the deadly combination of guns and domestic violence? And 922G8 addressed protection orders, which are temporary, and so the prohibition is temporary, and said in one of its clauses that if you are a credible threat to impose harm on someone, on your intimate partner, that you can be prevented from having a firearm. And that was a categorical prohibition that the court accepted at face value, that we can prohibit those kind of people. But of course, there were no analogies to 1791 because domestic violence wasn't a crime. So if you're looking for a direct fit, which the courts have required in other civil contexts, it wasn't going to exist in Rahimi. So instead, they raise the level of generality and say, no, we're just looking for the principle of disarming the dangerous, which they found that at the founding, no one would have wanted dangerous people to have firearms. So we're going to use that as a basis to uphold 922 G8. Now, this level of generality and the focus on dangerousness did add wind to the sails of those arguing that we should be looking for individual assessments of dangerous going forward. That's the only way to live consistently with Bruen. But Rahimi was a categorical framework case, and so was, in my mind, Hemani. So that's how I think we see it differently. I think Hemani was a very narrow decision. It was under G3, which is the prohibition both for drug users and drug addicts. And Gorsuch said in many respects, this case is a narrow one. He made it clear we do not address efforts to ban addicts or those presently intoxicated from possessing a firearm, and those would be categories of people that would be found dangerous to have firearms. And they also made clear we do not address other prophylactic laws Congress might adopt about determining the use of a particular drug that poses a special risk of misusing firearms. So again, it's that concept of not only dangerousness, but also misuse of firearms that is part of the thinking going forward. They didn't want to touch 922G1 and nonviolent felons in this case, but they made it clear that they weren't, or proof that if a certain drug always makes someone dangerous or capable of misuse, it looks like they would be open to that as well. So I feel like all these cases going forward affirm in some way the Supreme Court's application of categorical approaches. So I feel that there are four reasons why 922G1 is constitutional. So I'm going to start with those four reasons. First, the cast out language. On felons, I would be remiss if I did not, like everybody else, say that language says these are presumptively constitutional. And that was reaffirmed. It was a reassurance in Heller, and it was a reaffirmed in Bruen, concurrence, Rahimi, and in many lower court cases, countless lower court cases that rely upon it. And it was recognized as important to the government role to improve and protect public safety by Alito. And as Roberts and Rahimi said, we do not suggest that the Second Amendment prohibits the enactment of laws banning the possession of guns by categories of persons thought by a legislature to present a special danger of misuse. So once again, the court goes out of its way time and time again to say categorical prohibitions can be okay going forward and that they are presumed lawful going forward. Now, let's get to the history. As I said, I find Professor Silva's history really interesting. and fascinating going forward, but there, of course, is history on the other side as well. There, at the founding, nonviolent crimes could be prosecuted, and the remedy could be the punishment could be death. The punishment could be forfeiture of your estate. Death was a standard penalty for serious offenses at the founding, and those included nonviolent offenses like theft, fraud, or deceit. And this was at the time that they were writing a Second Amendment saying your right shall not be abridged. So clearly there was abridgment that was happening. You couldn't see that you would allow for forfeiture of your entire estate and death, but not allow limitations on your right to have a firearm. I find that inconsistent. 922G1 and its categorical approach is consistent with other categorical analyses in federal law. The Armed Career Criminal Statute, which Lahny has pointed out, has disparate racial consequences, and I think those racial consequences are something that should be addressed. And criminal justice reform should be a part of all these discussions. But under the Armed Career Criminal Statute, the Supreme Court looked at this. The statute is 924E. Descamps versus United States is the leading case. And the question there is you get an increased federal sentence, which is a hefty one. It's a mandatory minimum 15 years if you have been convicted of 3 prior violent felonies. So the question for the court was, how do we determine what a violent felony is? And the statute says, 924E, that a violent felony is a felony, state or federal, that has as an element the use of force or threatened force against the person of another, or burglary, arson, extortion, explosives, or other conduct that presents a serious potential risk of physical injury. And the question presented to the court in Descamps was, if the statute is indivisible, meaning there are not multiple prongs in the statute, can we look at the underlying facts to determine whether or not this person is in fact violent or poses a danger? And the court said you cannot, that this modified categorical approach is only available for individual assessments if the statute is divisible. But if you have an indivisible statute, which doesn't have multiple prongs, then the categorical approach is the one that you should be applying. So it's upholding the use of categorical assessments. Also, in another statute that's near and dear to me because I worked on it for a really long time as a prosecutor was 922G9. And 922G9 is the federal prohibition on having a firearm if you've been convicted of a misdemeanor crime of domestic violence. And the question was, what is a disqualifying misdemeanor crime of domestic violence? In some cases, it would make sense to look at the underlying facts to determine if that, have an individual assessment of whether or not that person was a danger to their intimate partner. But instead, the statute looks at crimes, looks at elements of the offense. So the facts are irrelevant. So if someone had been convicted of violating a protection order and the facts underlying that crime were incredibly violent, that still would not be a disqualifying offense, a predicate offense for 922G9, because the elements of the offense do not require any use or attempted use of physical force. So another case where the court has affirmed, and 922G9 has been affirmed several times, several rounds through Supreme Court litigation, of only looking at the elements of the offense rather than the facts. Several courts now, as Lahny mentioned, have gone through this analysis post-Bruen and looked at 922G1 as to whether or not it would apply categorically to both violent and nonviolent offenders, and has found the 10th, the 9th, the 8th, the 5th, and the 4th, to just give some examples, have all held that the categorical approach to 922G1 is constitutional. In Vincent versus Bondi, the 10th Circuit, the underlying predicate was a $400 check fraud, but it said that neither Bruen nor Rahimi invalidated G1 and its categorical approach. U.S. versus Duarte, the Ninth Circuit en banc, held that prior felonies for vandalism, evading a police officer, felon in possession, all were allowed under the categorical basis for looking for special danger of misuse. And the court wrote, it is difficult to conclude that the public in 1791 would have understood someone facing death and estate forfeiture to be within the scope of those entitled to possess firearms. Jackson, the Eighth Circuit in 2024, two prior drug convictions were the predicate for G1. It rejected the individual dangerousness framework, saying convicted persons create a threat to orderly society and disrespect for legal norms. If you are not law abiding, then the legislatures traditionally can use status-based restrictions for both persons who deviate from legal norms and are dangerous. U.S. versus Diaz, the Fifth Circuit in 2024, the vehicle theft was the prior. And the court said, nope, if capital punishment was permissible to respond to theft, then the lesser restriction of permanent disbarment under G1 is also permissible. And Hunt from the Fourth Circuit also. So I realize time is running short and we want to give people a chance to answer questions, but I think the categorical assessments are analogous to the history, even if they are abhorrent categories. I understand that these categories should not be cast in stone and that criminal justice reform and restoration possibilities should all be a part going forward. But I don't think that individual assessments are the answer to how we provide remedies going forward. It is the role of our responsibility of our governments in creating a peaceful society where all can enjoy life, liberty, and the pursuit of happiness. And I think categorical assessments under G1 provide that.
Okay, we have 2 minutes, so maybe what we'll do, if it's okay with our speakers, we'll give Lahny maybe a quick minute to share some thoughts. Margaret, I got the feeling that you replied to all of Lahny's points in your presentation.
Yeah, I'm all set to go.
Okay. So Lahny, maybe take a minute, and I see that there are several questions in the Q&A, which Lahny has answered some of them. So maybe we'll give Lahny the last word here before we close. And
Well,
then we'll leave
I'm
the Zoom open a bit just so everyone can look at the
No,
Q&A.
this
Go
is
ahead. Go ahead.
great. Thank you. I was in the middle of responding to a comment about the 25% of the colonists. I actually have two sources for that person, and 40% of those coming over were actually convicted of violent offenses. So I disagree with that they're not being 25%, but I'll respond to that in a minute. So a couple of things. I totally agree with you about the Second Amendment not being absolute. I loved your discussion about the civil versus criminal, dichotomy and distinction. Also, that there's really no history. That's right on point. That Rahimi is walking back kind of the expansive language of Heller and McDonald in Bruen. But I have a bone to pick with you about the categorical approach. I mean, Hemani just came out, and Hemani says the exact opposite, right, of what Rahimi says about the categorical approach. Categorical dangerousness, as I mentioned in the presentation, Gorsuch is citing Justice Barrett in Cantor versus Barr, who clearly states that categorical dangerousness is a problem. And so I think that's even a bigger problem for our understanding of where the court is going with this categorical dangerousness. I heard you with the greater versus lesser argument that we have Chief Justice Robert discussing in Rahimi that, hey, if we could kill them, we can disarm them. And, I think that's problematic for a number of reasons. Number one, something that Justice Barrett said in Cantor is that we really didn't know what felonies were. And in America, they weren't developed, they weren't shaping up the same way that they were in England. And practically speaking, England wasn't even executing felons in the sense that we would think. Yes, they were sentenced to death, but they weren't actually executed. The categorical approach that you mentioned with the Armed Career Criminal Act, we've had different enhancement statutes struck down. And one problem that we see is that the categorical approach is unworkable. So that's always kind of been a problem for the court. We can't get a concurrence on whether that's a good thing or a bad thing, or if we should be looking at actual conduct. And what I will say is that Justice Thomas would strike down 922G right now if he could as an overstep of the Commerce Clause. And so I do think that 922G as a statute is in trouble. Now, do I think that, felons should be disarmed? No. But do I think that there are some people convicted of crimes that should be disarmed? Yes. I do not want to live in an unsafe society, and I think that's important. I do, George, really quickly want to address Mr. Rutland, who makes a very persuasive point about the percentage of people that were criminals in America, and I disagree wholeheartedly. I've researched this. I've pulled books from the time, and all agree that have been writing on this that 25% of the American population were criminals. I see that there's an encyclopedia on that period. It's actually not correct. So I am happy to send this commenter some information if you would keep the stream open so I can send him my sources. I had a lot of fun today. Margaret, I thought your arguments were awesome. I wish that I was practicing in your jurisdiction so we could have actually had a trial and litigated. I think that would have been a great trial. And thank you so much, George. I really would just want to send this comment
Yep.
to my sources.
We will. Thanks to you, Margaret. Are you all set? Any other closing thoughts?
I'm all set, but I realized that I
Okay.
went too long and I apologize for that.
No
So
worries.
Okay.
I'm able to stay on if there are other questions going forward.
We're a very flexible outfit here. You're fine. So thank you very much. I'll leave the Q&A open for about another 10 minutes or so. I'll just say I'd like to echo one of our participants' comment here that says, excellent presentations. Thank you very much. So many thanks to you both. To all of our viewers, as usual, the video will be up on the Firearms Research Center's website, firearmsresearchcenter.org, in the video library section in about a week or so, probably a little sooner, but give us about a week to get that up for you. And Lahny's PowerPoint presentation will be on the events page for this session in a couple of days as well. Again, give us about a week, but hopefully it should be up there. We try and do these seminars about once a month, so please keep an eye out for the next invitation or for the next notice that we're having one. And I'll also give our presenters here a round of applause and thank them and all of you for joining us. Thanks very much.
Thank you, George.
Thanks for having us.